Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Looking at a very interesting book that's come from us to us from Routledge. It's one of a series of books they've been producing. These are high-end books, if I can put it that way, in terms of the legal arguments that are developing. The question then is who it will appeal to in terms of the content of the book itself. This particular book certainly is a book, I think, which would be of relevance to constitutional lawyers, looking specifically at some aspects of the way in which we do some of our business, certainly in connection with the whole concept of this, what I call this human rights issue, because it hasn't gone away at all, it won't do. But we've got to look at the various contributions that are taking place as we move the issue of the maintenance of human rights forward. This book has got a title which probably to some of you is a little bit confusing, but I'll explain what it is. The title is Contingencies, Resilience and Legal Constitutionalism. It's been edited by Clive Walker. It's from Routledge, which is an Informa Business, part of the Taylor and Francis group. Now, my wife Elizabeth and I looked at the book, and we didn't initially respond by trying to understand what he was trying to get at, because initially it was a little bit confusing as to what he was actually talking about. Having said that, once the penny dropped, as it were, and it dawned on us what it was about, all became quite clear quite quickly. The title, therefore, we gave our review was Law and Governance in the Management of Contingencies and Risk, because we are actually looking at the issues of risk. Now, that can mean a lot of things to a lot of people, and I'll talk about that in a minute, because I used to teach risk management. I mean, anybody who's a lawyer, if you're a solicitor and you can choose your clients, you run a risk with your clients. If you're a barrister, of course, under the cab rank rule, we don't. It's a slightly different position. Here's the book. It's a very small book, hardback, front, spine, nothing on the back. It is listed as just as a Routledge book. It hasn't given any particular title. It runs to 140 odd pages. It's not a big book. I'll start at the front. That explains what it says there in contingency planning, and I'll talk about that in a bit more detail in a minute. You've got the 9 chapters and an index there listed. Citation information, contributors, a number of people contributing, so it's been edited by Clive. The citations are there to tell you who's done what. Then there's a note of the contributors. As I said, it's a very small book, this one. Then legal perspectives we have going straight in, the papers involved and so forth. And then you've got a lot of, at the back of each of the chapters, you've got a lot of notes. So for instance, this next chapter, again, same structure again, an introduction. Then right at the back, you get a conclusion as to where you are, and then you get your detailed bibliographical notes. And if we go right to the back, you've then got the index, not a particularly big one, but useful enough there. And then after that, you've got the very last chapter. And then, so say the footnoting is at the back of each chapter, which in some ways, it depends on how you want to do things. I think for this book, small book, 140 odd pages, it works pretty well. So let me talk about what this is about, because I've been involved in some areas of this particular subject matter in the past. This is what we say, edited by Clive Walker and published by Routledge. This book originally came out of a special issue of the International Journal of Human Rights. That's the starting off point. It's therefore a collection of learned articles from this journal written by 9 experts, including the author, that's the main editor, in diverse but related areas of study, which basically deals with the various legal implications implicit in risk management and or risk mitigation, limiting the risks that you might be being faced with and the legal framework therein. Okay, so that's where we come from as a starting off point. So the title is not a very helpful title, frankly, to indicate what the book's about until you get into it and you see what the sum of knowledge is that is coming out. The expert view is that we live in what is referred to as a late modern risk society, threatened mainly by terrorism, the consequences of climate change and natural and man-made disasters, and characterised essentially by high levels of unpredictability and low tolerance of risk. Within these realities, contingency planning and resilience are of prime importance, with all the attendant implications for law and governance. Of course, within that you can include, obviously I mentioned climate change, that's the environment. You can talk about man-made disasters as a result of what we've been doing by tinkering with the environment. Then you've got the joker in the pack, which is the evil, which is international terrorism. That's criminality on an international scale, has no boundaries, no morality, no nothing. It's anarchy gone mad, and the problem is we have to pick up the pieces. Now that's really where we're coming from, because risk management, and if you're an elected member, say, of a local authority, you will have an emergency or a disaster planning officer to deal specifically. Normally, for instance, I live in Richmond, we've got three major problems. We've got a river, we've got the airport, Heathrow, and we've got we've got a main railway junction, and we've got a main road. So you've got all the transport issues. You've got the river, which is the environmental issue affected possibly with climate change and so forth. So you see, all together you've got all of that being brought in. Then if you have a terrorist outrage on top of it, that's when you need to start thinking of contingencies, what contingency plan you have, the resilience that you can put up, and the legal constitutionalism involved about how much power you can take and so forth. Now, as Professor Emeritus of Criminal Justice Studies at the School of Law at the University of Leeds, Clive Walker points out that our risk society continues to seek ever more complex and detailed risk mitigation responses by law. Well, what does that mean? Well, that means mitigation means lessening. So it's the lessening of risk. That's actually what he means. As examples, he cites the UK's Civil Contingencies Act, an important piece of legislation, one that I certainly welcomed. I was a councillor at the time. We'll talk about that in a minute. And then, of course, you've also got the US Homeland Security Act 2002, which is a response, of course, to the appalling atrocities of 9/11. Now, it's important to note here the article by Amos N. Giora, which discusses issues relating to Homeland Security, which primarily involve framing Homeland Security and articulating criteria for its effectiveness and accountability. Now, I think it's interesting to note that this particular author proposes a definition of Homeland Security when invited to testify before the US Congress in 2008. And it's a definition which, amongst other criteria, called for, quote, a realistic strategy which must prioritise threats according to their probability and imminence. Well, that's partly true, I suppose, but if you think of it from an intelligence and security perspective, you might actually want to have a bit more longer term planning to stop it or nip it in the bud, if I can put it that way. But of course, my basic contention there, when I'm looking at reviewing this work, would be to say you've always, of course, got to have reserves. Now, it hasn't been that long ago since certain party political ideological groupings did not see the need to have reserves, so that when you had a problem, you didn't have any contingency backup. And I'm not going to refer to Mr. Blair, and I'm not going to refer to anybody else, but I think you must see from the point of view of legal constitutionalism that the public would expect us to be protecting ourselves and our environment a little bit. Now, that's without getting party political. Let me continue by saying other articles, of course, in what is actually a very thought-provoking volume, small though it is. It certainly got me thinking intellectually, I must say, about the matter. Hence the fact I'm talking at some length about not just the intellectual element, but the practical elements that are involved. They look at things like lone wolf terrorism in Norway. So these are really appalling matters we've had to face and hear about. Canada's emergency measures on legislation, again from Clive Walker, the governance of emergency arrangements, and of special interest to policymakers as well as lawyers, is the Keep Calm and Carry On article, which includes an examination of the United Kingdom's CCA Act. That's the Civil Contingencies Act 2004, which, as I say, I welcome to a certain extent. The legislation being designed to provide a framework which effectively governs the planning, preparation for a wide range of potential emergencies, from terrorist incidents and cyber attacks to flooding. Now, I mention that because every local authority should have a disaster emergency officer, and there are very good courses at Easingwold, which I've done, which are extremely helpful to elected members. The reason I mention that is because quite often, when some of these problems arise, the guys who are normally there to do the job aren't around, and it may well be that the only people who are around could well be elected members. And that has happened in the past with things such as the Clapham Junction rail crash, which featured some years ago now quite heavily in the training at Easingwold. Now, I've gone off at a slight tangent here, but that I think does assist probably Clive Walker's intention with this book of pushing this subject matter forward, making it more recognisably important for the general public, who frankly will take a lot of this. They don't want to talk about it. They'll take a lot of it, as just dealt with. Obviously, if one goes back to Cold War era problems of things like a nuclear war and devastation, you've then got contingencies for something like that. But we are looking here at problems concerning current types of natural emergency or man-made emergency. So taking a comparative stance, the book sheds considerable analytical and frequently critical light on what one might term the legal response to contingencies, what happens, and resilience, the most desirable response to what happens. I would add cost, of course, comes into it, but we won't talk about that. Constitutionalism implies or more or less demands a desirable and carefully considered response to what happens, grounded ideally in the standards and principles of legality, effectiveness, accountability and individual rights. So what you're talking about in general terms then is getting the balance right. So if you're in a local government scenario, to use the expression, in other words an elected member or an official, you've then got to bear in mind your legal responsibilities and your relationship and your responsibility to the local community. And I think that's what's trying to come out of this, because you have to balance it with the overall constitutional framework within which we live, which is really why it goes back to where these articles appeared initially in the Human Rights Journal, because it is probably partly about human rights, but it's more specifically about the sort of risk planning we have to do for things. I mean, the word that isn't mentioned is asteroid, and Lembit Opik would be probably very unhappy that it hasn't been mentioned, but the fact is that that's another classic example of an emergency which we basically could do nothing about. Let me conclude by saying, featuring in depth and careful scholarship and a prodigious amount of research references, the book we think should certainly excite the interests of academics, comparative lawyers, government officials, and indeed anyone involved in any aspect of what's a varied and challenging area of concern which affects all of us. And that's something, as I've said before, which we largely don't want to talk about until it happens. And when, as it did, I'm talking specifically about the Clapham train disaster and other ones that potentially we could have in the future, although we are very well served, I hasten to add, by highly maintained stock and so forth. But these things do happen, and when they do, we've got to have something there to try and help. That's what this book helps. It does continue the debate. I say there has been some dogma by some party political groupings who don't see the need for this sort of thing and are very cynical. But I think the bottom line is that anybody with responsibility does recognise you have to do it. Blair did, and I wasn't too happy with his legislation in some areas because of the financial implications for local authorities, but that's a different issue. That's nitty-gritty rather than the overall broader concepts issue which Clive Walker has tried to produce. Thank you very much indeed. I found it fascinating from a high perspective. I'm very grateful for its contribution. Bye-bye.